Welcome everybody to our webinar on managing corporate immigration risks, what in-house counsel needs to know. I am Stephen, the Enterprise Account Executive here at LegalVision, and I'll be emceeing this webinar, and we're joined by one of our practice leaders, Yin, to talk through all things immigration and what those risks looks like for the business. Now, before we begin, a couple quick housekeeping items. After the back of the webinar, you will receive the recording and the slides in your email. Any questions that you have throughout the webinar, please submit them through the Q&A box and Yin will answer them at the end. We will send out a feedback survey off the back of the webinar. If you are able to complete that, that'll be fantastic. And if you stay until the end of the webinar, you can actually enter our Apple AirPods monthly draw. So a little bit of fun and a little bit of a game to win there. Now, by coming to these webinars, you are eligible for a free consultation with myself and the enterprise team here at LegalVision to learn how we can support your in-house team and help them manage some of the high volume business as usual legal needs. If this is something of interest, there will be a section in the survey at the end to provide your contact details, but I'll dive into this a little bit further after the webinar. What I'll do now is, Yin, I'll throw it over to you to talk through what we'll be looking at today in the webinar, and we'll go forward from there.
Thanks, Stephen. Welcome, everyone. We're so pleased to have you today at our webinar. And obviously, we'll be talking about all things corporate immigration and the risks that Australian businesses, employers need to be aware of when they're looking at employing individuals on temporary visas and when they become, or if they are already an approved business sponsor. This is our agenda today. As you can see, there's quite a bit to cover. I'll sort of talk briefly about why this is quite an important topic and issue, and then discuss and outline some of the key immigration risks, and then obviously go through in quite detail some of the temporary visas that an employer should be aware of and what conditions apply to them. And then we'll actually break down the sponsorship obligations because they can be quite confusing at times as well. And then what would happen in the event of non-compliance. So let's get started. Why is this such an important issue today? The reason is that historically, immigration compliance, understanding the risks from an Australian business perspective may have been overlooked in the past, or may not have been afforded the appropriate importance that it should. I think there's been a number of things that have changed in the Australian migration climate, such as stronger compliance, sanctions, and enforcement and monitoring to ensure that migrant workers are not exploited. So this is on the part of the Department of Home Affairs through its sponsoring monitoring unit, and then their enforcing officers, which are the Australian Border Force. So the immigration component of it, when you employ someone that holds a temporary visa, when you sponsor someone on an appropriate work visa, there are a lot of implications for businesses these days, and we're going to explore that in a lot more detail. So the first is having an appropriate attitude where you as a business owner or as a representative of a corporation, you appreciate that those risks could potentially land you in hot water if not appropriately dealt with as well. Okay, and there's a lot of issues these days because you're dealing with a lot of complex situations, understanding the appropriate visas that the employees hold, global mobility issues, intra-corporate transfers, and obviously the tenure and employment of a sponsored employee as well. So as I originally mentioned, the main body that enforces obligations in respect to approved sponsors and those that employ temporary visa holders is the Australian Border Force, and they have very wide-ranging powers, and they often work in collaboration with the Fair Work Ombudsman and Commission. Okay, so let's move on to the next slide, which is what are some of the key risks that happen? Well, often the key risk is visa compliance failures. So this is where an Australian business employer may not understand their employees' temporary visa situation. They may not understand the conditions that apply, they may not understand the work rights, and they may be inadvertently contributing to some form of breach, which is obviously not a good thing as well. So then it can be as well not conducting appropriate work rights verifications, because there's a very simple process to do it, and we'll obviously talk about that in the strategies of what you can adopt in your business. And then the second most important risk that comes up is not understanding what your sponsorship obligations are. So a business Australian employer may apply to become an approved sponsor for the purposes of sponsoring someone on a 482 or 494 visa, and they may not actually understand what obligations apply to them and the duration those obligations apply to them. So this is where this happens quite a bit in do-it-yourself sponsorship applications, or if they're pretty much taking the lead from the actual employee, where they may consider, well, this is the employee's visa that we're doing, so we really don't have a lot of input but to provide documentation. It's not the case at all. You have a great deal of input, plus there is a great deal of information and obligations that you need to be aware of. And so then how does an Australian business employer fulfill their obligations, comply with their obligations when certain events occur? Okay, because it's not a one-time situation. It often sponsorship obligations are for the span of the sponsorship approval period, which is 5 years and sometimes up to 7 years as well. So there's a lot of things that can happen within that period where you need to be aware of, well, what do I do in this circumstance? Do I notify the department? Is this a situation whereby we need to lodge a new application? What is it? What are the proactive steps that I need to take, or even the reactive steps that I need to take? And then the last part is ineffective record keeping, not having appropriate systems in place to check visa expiry dates, not having appropriate documentation that shows the sponsorship employee arrangements, and obviously not having that information available if the Australian Border Force was to conduct an investigation. Okay. And so then what are some of the conditions? Let's talk about situations whereby, because an Australian business employer can be an employer of temporary visa holders, and they can also be an approved sponsor that sponsors on a 482 and 494 visa. So obviously this is very common. It's understanding what are the temporary visas that some of your prospective employees or even current employees currently hold, and then being able to understand what needs to be actioned in that record, and then obviously mitigate risks. So some of these temporary visas you may be aware of. So you don't need to be an approved sponsor to hire someone, engage someone as an employee if they hold a working holiday visa, if they hold a student visa, graduate student visa, or they are a member of a family unit of a New Zealand citizen, or they are a New Zealand citizen, secondary applicants, family migration visas as well. But they're complex because they are all different types of temporary visas that have specific conditions on them. And then you may be dealing with an employee that may be the primary applicant or the secondary applicant to, say, a student visa or a graduate student visa, and therefore the conditions may be different. And then it gets even more complex if you're dealing with someone that has quite a complex immigration history and they may be on a bridging visa as well. So some of the complications that can arise and that we get questions around all the time is, well, how do we accurately calculate the 6 months working with one employer condition that pertains to working holiday visa holders? And obviously there's a lot of information on the Department of Home Affairs website, and there's a lot of exemptions around it. So it may be around incorrectly assessing the calculation, particularly if we're talking about hybrid working arrangements, people working part of the time from home, people working part of the time in the office as well. What are the implications or in respect to that condition when that temporary visa holder applies for the second or third working holiday visa, or they transition onto a bridging visa from that first to the second working holiday visa? So typically the 6 months with one employer resets. It resets when they're granted a second or third working holiday visa. It resets when their bridging visa associated with, say, the second or third working holiday visa activates as well. So it's really about understanding the appropriate timeline, because you can actually plan quite effectively for a working holiday visa holder to work with your business for 6 months. Then they've applied for the second working holiday visa, depending when the bridging visa activates. That's another 6 months with you as well, okay? And then in all other situations, you have to consider if an exemption applies. The last resort is actually requesting an extension to work longer with the same employer, because it's the criteria is very conditional and it's very specific as well. The same goes with student visa employees, whether they're the primary or the secondary applicant. Typically, they can only work 48 hours per fortnight while their course is in session, but it also depends on the course that they're studying. Usually, if the primary visa holder is studying a master's in research or a PhD, they can work full-time, so can the secondary. If they're studying a master in coursework, they can only work part-time, but their secondary can work full-time. So it's really about understanding all this. And then obviously it gets quite complex when we talk about bridging visas, because there are 6 different bridging visas as well, and they can have different conditions. So where it's unclear, it's always important to get advice around that, because usually the employee's previous immigration history really informs around what the conditions are that apply to their current visa, particularly when it relates to bridging visas as well. So the next and most important part is really understanding sponsorship obligations. So there will be a lot of Australian businesses and employers that become an approved sponsor, and they obviously sponsor someone on a 482 or even a 494 visa. 494 visa being the regional employer-sponsored visa. And so often the first approach is that you've got an employee, they're on a temporary visa, they come to you and they say, hey, can you sponsor me? So you think it's just a process of lodging applications. But with the application to apply to become an approved sponsor, there are quite a lot of obligations that apply throughout the validity period of the sponsorship, and while you continue to sponsor that person on a 482 or 494 visa. So we'll go through them, and some of the obligations are quite self-explanatory, but I've provided some case examples to provide a bit more context. And obviously, some of those obligations, you need to consider it when certain events occur. And as I said, a lot can happen in a 5-year, 7-year period, or even in respect to the tenure of employment with a sponsored worker. So cooperate with inspectors. I mean, that's quite self-explanatory. When we refer to inspectors, you're referring to the Australian Border Force. And so we'll talk about that in the next slide, the powers of the Australian Border Force. Ensuring equivalent terms and conditions of employment. Basically, it's ensuring that you continue to meet the minimum employment entitlements for that sponsored worker, and those minimum employment entitlements have been extended to all your workers, regardless of whether they're Australian or on temporary visas. So you have a uniform employment framework in place within your Australian business organisation. Pay travel costs to enable sponsored persons to leave. So this is, often a key issue of contention. And often the questions I get asked is, well, if this sponsored worker is dismissed due to misconduct, do we still need to pay these costs? The short answer is yes, you do. So obviously it's only in respect to reasonable travel costs. And it's really if the sponsored worker or the former sponsored worker asks or requests that in writing as well. So I'll give you a little scenario here about Marcus's situation. So it doesn't matter how the employment ceased, how it terminated, whether it be made redundant, whether there was a formal resignation, whether it was a cessation due to misconduct, it absolutely does not matter. So as a result, provided that you have undertaken, the approved sponsor undertaken their own independent research, because you don't need to be bound by the bill that the sponsored employee sends you. You can actually do your own independent research and determine these are the appropriate travel costs. I'll pay those travel costs. I've done my research. I've obviously recorded all this information, and I'm satisfied that I have met this obligation. Okay, I won't go into the next obligation, pay costs incurred by the Commonwealth to locate and remove an unlawful non-citizen. It's a very rare situation where that would occur, but it typically means that if by some reason your sponsored employee becomes unlawful and they are therefore detained by the Department of Home Affairs, the Australian Border Force, then the sponsored employer may receive a bill from the Department of Home Affairs to pay for the travel costs to return. But actually detaining someone in immigration detention is very serious. It often does not apply to everyone. So we'll move on to the next slide as well. Okay, keep records is very important, and often, assisting a lot of Australian businesses with their Australian Border Force investigations and audits, that can be overlooked at times as well. Provide information to the minister and provide information to the department, notifying the department when certain events occur. So I've got some case studies for you at the moment. The most common one I'm seeing a lot of is where there's a change in business address. And it's not even in respect to that solely. It can be a change in director, change in shareholders. Those sorts of events require the approved sponsor to notify the ABF within 28 days of that event occurring. And I've seen many instances where that's not been done and the Australian Border Force has taken action. And we'll talk about that momentarily as well. And then the second case study, which is very common as well, where you sponsor someone and say you sponsor them as a marketing specialist, but their duties change. So it's really important to understand, well, when their duties change, is this simply the approved sponsor notifying the ABF of that change, or does it change the position fundamentally that it's no longer the same occupation that we originally nominated the person in? And if that's the case, then more action needs to be undertaken here, such as lodging a new visa application. So obviously we appreciate that. Now, there's a couple of other factors that occur too, such as if the business decreases the salary of the sponsored worker, that's obviously problematic. That's not something that requires a simple notification. That actually requires you to lodge a new application as well. Okay, so let's talk about sort of the cost of non-compliance, because I've given an overview of what could happen in some of the specific case studies, such as, the Australian Border Force can take action such as cancelling the sponsorship, barring them from sponsorship, making them pay penalty notices, issuing them a formal warning. It really depends on the actual circumstances, whether it's a one circumstance or there's a pattern of circumstances that have led to this overall breach as well. And so when I outlined the sponsorship obligations, you could see there's about 10 of them, for instance. These are all specific obligations that must be complied with. So with the Australian Border Force, if they determine that an Australian business has breached one or some of those obligations, that will be considered an individual breach. That will be something that they will assess in determining what the overall sanction will be. So obviously, if you breach one obligation and it is a one-off circumstance, then you may have an Australian Border Force officer that will, be lenient, understand. If we're talking about multiple patterns here and identification of multiple breaches, it's obviously going to become quite problematic. Now, the Australian Border Force is the one that enforces, monitors sponsorship obligations. They obviously sit within what's called the Sponsoring Monitoring Unit of the Department of Home Affairs, and they have very broad discretionary powers. And that was actually widened at the end of 2023 through an appropriate introduction of a bill. So obviously their key remit is to ensure that there's no exploitation of migrant workers. But at the same time, their role is to conduct various audits and investigations. So what their power is, you could receive, if you're an approved sponsor, you can receive a notification from the Australian Border Force pretty much at any time requesting that you provide information. And it could be records of pay slips of your sponsored workers. It could be information about, how you came to an appropriate salary for your sponsored worker. There's a lot of information they can request, and they usually want you to provide it to them within 14 days, which is a very short amount of time. So this is where it's appropriate. If you have managed or kept clear records, that information should be easily accessible if you're called upon by the ABF to provide that. They can also have powers to obviously visit and attend businesses' premises. They don't have to provide notification. They don't have to tell you in advance. They can just obviously show up. And obviously, if you're not familiar with this, they usually come with a group of them. And they look very official and they look like police officers. And they can obviously ask to speak to anyone in the organization, and they can obviously interview and record those interviews and so forth. Okay, so a lot of wide-ranging powers here. There's actually a bill being introduced into Parliament as we speak. So currently we have a register of the sponsors that have been sanctioned. We don't have a register of just approved sponsors. So the bill is looking to introduce a register of just approved sponsors that will provide actually information about your business, such as the business name, the address, the ABN, so forth as well. So that's currently underway. So what can happen is a multitude of things, and there's usually a due process that the Australian Border Force will provide. So the first is they request information, then they may consider whether to conduct a formal investigation or audit, and then ultimately, if they determine that there's been breaches, they'll issue what's called a notice of intention to take action. The employer sponsor is afforded every opportunity to respond, provide a reason, to defend themselves essentially, and to demonstrate to the ABF how they've sort of learned from their mistakes. But if that is not accepted by the Australian Border Force, then as I said, they can cancel the sponsorship, they can bar them from sponsorship, they will publish that sponsorship sanction on their public register as well. They can issue monetary penalties, and this will be all adverse information too. So if you think that, okay, if I'm being barred from sponsoring someone on a 482, 494 visa, I can probably look at sponsoring them on a training visa or some other temporary visa that requires sponsorship, or maybe, just nominate someone for permanent residency. Think again, because it is adverse information that can't be disregarded as well. So knowing all those risks, understanding, all that in place, and understanding, what are some of the main issues that can arise. It's really about working with an appropriate legal practitioner that is experienced in this area to identify the risks within your business. So taking proactive measures. So if your record keeping is not appropriate, if you completely don't understand your sponsorship obligations, if something specific has happened and you don't know how to deal with it, then obviously reach out to a professional where we can obviously conduct training. We can show you how to put in appropriate internal compliance systems. We can go through your record keeping, for your sponsored workers to determine, well, what's lacking here, what's missing, how to manage that going forth as well. So how do we build an effective compliance network? Well, first, it obviously starts with you understanding as an Australian business that this is a risk that your business can't afford to breach or have some kind of adverse action taken against them. So then understanding, well, what is your current composition of the workforce? Do you rely on temporary visa holders? Because there's some industries that do. We are obviously facing a skills shortage. So there'll be a lot of key industries that will have a appropriate size of their workforce that are temporary visa holders. Do I just employ temporary visa holders, or am I also an approved sponsor? If you're both, and most clients that we work with are both, then it's about understanding, how do I understand what temporary visa that they hold? How do I conduct the appropriate work rights check? Do I just do it once, or do I do it on a regular intermittent basis? And how do I keep track of that? And then based on my interview meeting with the employee, how do I maintain that information record so I can go back to it? So if I was ever called upon by the Australian Border Force to provide that information, I can provide it with ease as well. Definitely get training as well. So LegalVision provides sponsorship monitoring and compliance training. We have a manual. We do a full breakdown of what are some of the key immigration risks within your business and how to obviously mitigate that, and how to put forward or implement effective systems and processes. So training is key here, because you don't know how to adopt appropriate measures and systems if you don't understand what the risks are. And then obviously once you receive that training, train your appropriate staff member. And then understanding that with immigration compliance, there really needs to be either a key representative of the business or a key team within the business that manages this accordingly. So this may involve things like making sure that contracts are up to date, making sure that market salary research is current and pertinent. It may be around, understanding what are some of the things that have occurred within the business, what are some of the changes that have occurred within the business that may actually require us to notify the department accordingly, so we are not in breach of our obligations. Okay. And so, as you can see, lots of things to consider here as well. We've given you some ideas around, and it really starts with that internal systems process, and then what is the appropriate exit strategy for some of your employees. So particularly when we're talking about sponsored employees, what are your obligations when that employment ceases? Okay. So, that pretty much covers the webinar today. As you can see, I've gone through it at an incredibly high level, because with each component there is a lot to discuss. So just a few tips here of when you should seek immigration specialist advice, because for some businesses, they may not be presented with these issues, meaning that they don't have a lot of temporary visa holders that they employ or sponsored workers. But if you do, then obviously seek advice if you've been contacted by the Australian Border Force, whether it has been through email correspondence, or whether you've received a phone call, or whether there's just attended your premises. Really understand or conduct specific training, meaning obtain specific training. Understand when certain things happen within the structure of the business, such as mergers and acquisitions, how that can impact your current temporary visa holders and sponsored employee workforces as well. And then recognizing when there's been an inadvertent breaches, and then how to take proactive measures so that your standing as an approved sponsor is not impacted. So thank you everyone very much. I'm going to hand it back to Stephen to sort of talk you through our next webinars, a few other things. And then if you have questions, I'm going to now be answering the questions after he's gone through that.
Thanks, Yin, and a great webinar and really important topic points for a lot of businesses, especially when it comes to immigration. Now, if you wanted to download our free guide looking at sponsoring foreign workers, It's in both the resources tab of this Zoom call, but you can also scan the QR code on screen to download that. You might also be interested in joining us for our next webinar on the 10th of December at 11 a.m. Australian Eastern Daylight Time, which is looking at preventing wage underpayment in your business and supporting you in that regard. If you want to register now, there's a link on screen. Otherwise, we'll send the link out via email. Now, off the back of this webinar, I thought it'd be really interesting to talk about our desk extension solution for in-house teams and growing enterprise businesses. We'll answer all your questions shortly, and Yin's looking forward to any live questions that have popped up. But after speaking with many in-house counsel teams and general counsels and growing businesses, we know that there's a constant pressure to manage strategic input and business growth with that heavy load of day-to-day matters that come with just managing a business in-house, especially on top of a very tough labor market, trying to find the best lawyers for the best, wages and prices. Now, the idea of the desk extension service is to support the business in their day-to-day business as usual legal needs, everything from your commercial contracts and agreements, IP data and privacy, as well as everything from employment and the like. Now, off the back of this call, what Yin and I are also suggesting to businesses who are interested in learning their immigration risks and what that looks like at a more necessary level for the business and a bit more specific is we are running free consultations off the back of this call. If you're interested in learning more about how we can support you, both in those business as usual tasks, but also looking at your immigration risks and what that means for your business, feel free to answer in the survey after this call, putting your name and number there. We'll reach out and organize that time to talk through where those risks are and do a little bit of a health check on your current legal standings. Now, I'm going to hand it back over to Yin to answer the questions that were pre-recorded. And if there are any other questions, feel free to pop them up as you ask them in the Q&A box. But at the moment, there's a quick poll on screen. If you don't mind answering that, and Yin, I'll hand back to you.
Thanks, Stephen. Yes, I can see some questions have come through, so I'll just obviously answer some of them. One of them that's quite interesting, which is things like, what's the likelihood of businesses actually being barred or, have their sponsorship cancelled? And again, it's very much a question of what has been the actual conduct, what has actually been the breach that has taken place. So I've seen it from what I deem is probably the less serious end to sort of very serious ends. And I'll give you some examples. So some of the case studies that I've put forward is things like not notifying the department when certain events occur, such as the cessation of employment, such as change of business address, things like that. If it's just one situation whereby they just forgot to notify the ABF of change of business address, then it is within the ABF's power to not take any action. So they may issue a formal warning. They may say, look, I'll let it go this time and just don't do it again. But, this is considered a formal warning. We're going to put this on your record and, we will be sort of looking at you going forward in respect to all your applications. And then at the very serious end is typically around things like where there's been underpayment, where the sponsored worker, it was represented that the employer will pay this certain amount when they were approved to sponsor them and they haven't done that, or not affording them the appropriate minimum entitlements as well. So, and then it could be multiple breaches of that in respect to multiple sponsored employees as well. So at that end, the department takes very serious or considers that to be very serious and is probably unlikely to, utilize or exercise their discretion to not take any action. They likely will. So the next question is, do I need to notify the ABF of change of business details if I'm an approved sponsor, but not currently sponsoring? Yes, you do. So if your approved sponsorship is still valid, so have a look at the sponsorship approval letter, and it's usually valid for 5 years. So you may have sponsored someone and they have obviously, maybe that sponsored employee has ceased employment with you and you're not currently looking at sponsoring anyone now. It doesn't matter. You still need to notify the Australian Border Force because it is part of your sponsorship obligations. It's still valid. Okay, it's really there will be some obligations whereby even when your sponsorship expires, you still have an obligation even 2 years after that sponsorship expires. So this is in relation to things like providing records around your previous employer-sponsored workers, things like that. And so just note that with notifiable events, change of circumstances, you've got 28 days from the date of the event, and it's important to record that. It's usually just a simple email that you send, and then you got to record it and make sure that you have all that information. Yeah. So then some of the other questions that have been asked is things like, so this is quite a common question around what are the guidelines around getting staff to pay for associated costs of sponsorship? So when you're looking to sponsor someone on a 482 or 494 visa, the employer sponsor must cover the bulk of the cost. So it depends on the application, but there's usually 3 applications here: the sponsorship, the nomination, and then the visa application. The sponsored employee or the prospective sponsored employee is only legally required to pay the cost of the visa application, the last application, but the employer must pay for the costs in relation to the sponsorship application and the nomination, all the government fees and the professional fees. But then also, if you've incurred other costs, such as, well, we had to recruit for them, we had to pay a recruiter's fee, advertising, relocation costs, that's not something that you can recover. And then obviously, if you've made representations that if you're providing them a sign-on package, for instance, then you need to sort of determine, has that been couched in the employment contract? Is that something that you can claim back from an employment perspective? But in terms of the sponsorship costs, there really is nothing that you can defer onto the sponsored employee. There are also, I didn't mention too, is that there's a number of temporary visas, right? But there are a number of temporary visas, and this is a specific questions around where they can engage in short-term work. We're probably referring to what's called a subclass 400 visa, which is a temporary, skilled, highly specialized work visa. But it is very much that you need to be able to demonstrate that the person that you want to engage is coming to Australia to undertake highly specialized, non-ongoing project work. So that 400 visa is really only valid for 3 months or 6 months maximum. Okay. There is also a question around age limit for employees. So when we're talking about employer-sponsored visas, 482, there's no age limit. If we're talking about 494, it's 45. And then there is an age limit with the majority of permanent residency visas, which is 45, unless there is some exemption. So I think I've gone over time. So I appreciate all the wonderful questions, all the interactions as well. So again, if I haven't gotten around to some of your questions, it is something that we can cover on a consultation later. But otherwise, thank you so much for participating and joining the webinar today. I'll hand it back to Stephen.
Thanks, Yin. Some great questions. And again, any questions you have that are a bit more company specific as well, it'll be great for you to let us know, and we can reach out for a consultation there. Again, submit your survey, your details in the survey at the end of the call for any assistance on the question we didn't answer, and to learn a bit more about the membership option if that is something we're looking into. And while this is a free webinar, we always value your feedback. So if you could provide any feedback at, things that were great, but things that could also be improved on, please let us know, because it allows us to make them better every time we run these webinars. Look forward to seeing everybody at the next one on the 10th of December. Thank you for joining us, and we'll see you then.